Thanks, Mr. Chair. I'll give you my thoughts on it in light of that. I'm sort of where, well, let me say this. I share the concerns that Amy raised, quite frankly. Um, I'm concerned about the First Amendment aspects of this, but I'm also concerned about the notion of clients coming to lawyers and needing to be very, very candid and open and honest about situations to allow the lawyers to give the best advice. So I'm concerned that we may have some chilling effect if we start allowing lawyers to disclose more, and arguably 1B and C allows you to do that. I'm concerned about that, the notion of does it lessen the confidence in the system if we are perceived potentially or arguably as allowing lawyers to do things that are contrary to the wishes of the client. So I'm concerned about that, one. And then two, I've put, I'm trying to look at this a little bit from the, I haven't been able to get away from this yet with my grievance committee hat on. And I'm looking at number 1A, and then it entangles our grievance committees in determining what's protected by the attorney-client privilege, what's embarrassing or detrimental, what's the lawyer's knowledge, what's the lawyer's research, what's generally known in the professional community. So the grievance committee has to decide all of those things. Public record, I think, is a little easier, quite frankly, a little more defined in my view. I'm thinking about, for example, if I look at legal research, does that mean that if a lawyer writes a memo that goes to the client, the lawyer then has the ability to distribute that memo to the public based on what's in 1A or 1B, or what is legal research? What is generally known in the trade field or profession? So I'm concerned about the broadness of that, quite frankly. And from a grievance committee enforcement aspect, I see it sort of fraught with peril if you've got the lawyer grievance committees now having to delve into all of these potential aspects to make these determinations about whether someone has violated the ethical rules or not. So that is a long-winded way of saying I'm concerned in some respects about making it broader. And I sort of lean, quite frankly, towards option 1C. That's where I think the public record is more defined. It's closer to what we have now, and I see us getting farther and farther away from what we have now with 1B or 1A. So I'm still open to being persuaded otherwise, but just reading through the stuff this morning, reading through some of the comments, and thinking about how our mission is to protect the public, to hopefully engender trust and confidence between lawyers and their clients, and how we enforce our grievance committees and how we follow our ethical rules. I just think 1C may be closer to what I think about when I consider all of those factors initially. So that's just some general thoughts I had initially.
Well, thank you, Todd. That 1C certainly addresses the First Amendment issue that the Virginia Supreme Court brought up. And this committee has always kind of set the First Amendment issues aside for the time being, because it's not up to this committee to decide constitutional issues. It's up to this committee to decide rule changes, if any. So, but it's, I think there was pretty much consensus amongst the original committee that if a lawyer did bring suit against the state bar, similar to the Virginia Supreme Court lawsuit, that we would lose. That the First Amendment trumps this particular restriction on lawyer speech. Other cases, as I recall, Brian, have upheld certain restrictions on a lawyer's speech, but in very limited capacities.
Hey, Eben, are you suggesting that the rule as currently written would likely lose to a First Amendment challenge versus what we're considering now?
I think that was the consensus with Amy and Bill and Suzanne back in the day when this really started off as just a review of the Khan decision. But Suzanne, do you want to weigh in on that a little bit?
So I'm not sure if what Todd is asking, you're asking if the rule that we have now would be unconstitutional, the one that we've had for a while.
Well, I know if we, for example, if we do nothing, I thought I heard that maybe there's some thought that if we do nothing, we may face a lawsuit in the future on First Amendment grounds along the lines of what Virginia did. And the consensus is that we may well not prevail in trying to uphold the existing rule. Whereas if we were to enact something that addresses, I know that's not our charge, Eben, if we enact a rule or propose a rule that addresses that, whether that short circuits the bar having to forego a lawsuit, but I know that's not our charge. But that was if that makes any more clarity, Suzanne, that's what I was driving at.
I think the concern was if we adopted the original opinion that stated that a lawyer could not discuss any of this information, the concern was that that opinion might bring some legal issues to the bar.
Right.
Okay.
Yeah, for what it's worth, I would say the rule as we currently have it, I think depending the nature of a confident or constitutional challenge and the success thereof would really depend on what speech it's addressing. I think we would have to kind of take that on an individual basis. But Todd, I just want to say I appreciate your perspective from grievance. That is one thing I will say, as much as I, with regards to 1A, my personal view, I do appreciate sort of, I guess, some practicality in offering a lot of explanation for lawyers and interpreting this stuff. However, the enforcement of something like 1A, from, I guess maybe this is me not able to take off my office of counsel hat or my deputy counsel hat. If I got a complaint and I had to prosecute that thing, trying to determine how I can prove that that lawyer likely knew or should have known, that the information was likely to be embarrassing is going to be incredibly subjective and a very difficult case to deal with. And I don't know, as much as there are more words in Rule 1A or Option 1A, but that doesn't necessarily clarify the issue for lawyers as they try to figure out what they can do in any particular thing. I think 1C is a bit more kind of defined in that regard. It's everything is confidential except the stuff that's the public record. And I don't know, Mark, to your point earlier, if there should be some sort of additional statement that does give the client the opportunity. I know you said, I don't know if that's how we want it to read or whatever, but do we have something where we basically add a new sentence that says if a client asks the information to be held in confidence, that the client may do so, or something to that effect, that essentially gives that client the ultimate control, regardless of whether it's technically confidential information or even public record information. It's just something to consider. I think, Ellen, did you have your hand up?
Yeah, you said two of the things I was going to say, one about the type of speech and constitutionality, and then also this idea of taking 1C and adding what Mark and Jack and Amy, I think Amy, sorry, anyway, talked about in terms of giving the client ultimate control. But I also wanted to just back up and make sure I understand Todd's comment, as I'm still learning how the state bar works. Because I agree with you, Todd, about the three pieces of 1A, and I wanted to address privilege specifically. I mean, would grievance be tasked with determining whether or not something was privileged for purposes of 1A?
If one of the defenses of the lawyer is this was protected by the attorney-client privilege, and I think yes.
Yeah.
And that is something I think for the grievance process, it's It's not unheard of. I mean, you can imagine we have Rule 8.4b that prohibits lawyers from engaging in criminal conduct that reflects adversely on their fitness to practice law. So not only do we have to go through the legal analysis of whether some conduct actually did violate the law, but then that extra level of, does it rise to that level of impacting their fitness as a lawyer? And so there are spots in our rules that for enforcement purposes require that legal analysis. It's not unheard of, but it does add an additional component for enforcement. And that would be here. Attorney-client privilege would require that. I don't know from an ethics perspective that we would necessarily have to go through that analysis with them. I was talking with Suzanne about this and Evan last week, and I think Suzanne correctly pointed out that our ethics advice would probably be, lawyer, you need to determine if it's protected by the attorney-client privilege. If you feel that it is, then it's going to be confidential. If you feel it is not, then then that's your analysis. But realize that interpretation is kind of on you, even though for enforcement purposes we may be reaching a different conclusion.
I think it's fair to say that if we are on the grievance committee dealing with a grievance, and we have listed sort of a get out of jail card, as you can say, you can prove it's protected by the attorney-client privilege. That's going to be one of the defenses that you will see.
Yeah.
To be sure. So I just want to mention that.
Yeah, for some reason it feels having the privilege, having attorney-client privilege, and I can't fully articulate it right now, but it feels odd having that there for a number of reasons.
Yeah.
Including the ease of confusion between the two that so many lawyers seem to have. It just, I'll think some more about it. But.
Now, we are constantly trying to explain to lawyers that the attorney-client privilege is not part of the rules of professional conduct, constantly. So I don't actually like it being part of the rule either. And generally, I like B and C better because I think they are not as expansive. I like the rule to say everything is confidential except, not these things are confidential. So for both of those reasons, I'm not a big fan of the first option.
Todd, how do you feel? Okay, Mark, go ahead.
Can I get one clarity? Please? Suzanne, do you read B as in, I'm just looking quickly. Does that cover information in the public record or not?
It could. I think it could.
Which would prohibit its disclosure as written.
No.
No, it would allow it.
Allow it.
Where under what part of it?
It's not included in B now, Todd.
That's what I'm saying, as written
Okay.
right now.
It would be an evaluation of whether or not the matter, the information that's in the public record is generally known. It would be kind of a dual analysis.
Okay.
In that regard.
Right.
Okay,
So it could be. I mean, it could
Got
be
it.
that it's in the public record and it's generally known. But
All right. I'm sorry to interrupt, Mark. I'm sorry.
No, that's okay. I think if we're going to go with that broad definition of confidential information, that it's anything gained during representation, we need to have a carve out for legal knowledge, legal research, right? If I'm engaged and I'm doing research and preparing that research and it goes into my law firm brief bank and then somebody else uses it or I use it myself 3 years later for a new client, I'm allowed to use that information. That is not confidential, even though it was gained during the representation of the client. And I'm worried that without a carve out there, you raise issues around whether that is, whether that would be permitted.
All right, Jack, go ahead.
I was just going to say on that point, which I think is a great question, Mark. The way I understood the rule currently is that if we're just talking about our legal research and then utilizing a hypothetical rather than the specificity of a case, then we can do it.
Right.
And then we can do it. And then as far as internal memos go, I think anyone else in the firm would be protected by in the same way that you would. So I think I could share that within the firm. If I wanted to share that with another attorney, that's all okay because we'd be under the same umbrella.
I agree that I agree you can share it internally. The concern I have is I've seen some outside counsel guidelines and some clients who sort of say, product that you create is my product. So if you're doing research and you create memos, that's mine just as much as yours. You agree to those guidelines or you don't. But I have seen outside counsel guidelines which try to make anything that the lawyer does that I'm paying you for as a client mine, or jointly mine, and you can't go use it and distribute it to the public as you see fit because I paid you for it and I have an interest in it, and you can't just go disclose it willy-nilly. I have seen those.
And I think that's absolutely fair. And as a practice, as a best practice, I try to make sure that if I write a big brief and incorporating facts and law and everything that I've done, I give a copy of that to the client. I think that's part of the practice. But I'll shut up.
I wasn't, I mean, obviously, if you draft that brief and you file it, it's probably public record at that point. I guess I was thinking more about an internal memo that you prepared for a client in response to a specific legal inquiry that is not shared outside. And then as written, does that mean that that legal research as memorialized in that internal memo yours?
Well, I think that would be protected by any legal knowledge I attain as an attorney representing a client then can be used not with the specificity again of the client, but as generic legal research. That's mine. That's my brain. Whatever.
Yeah, that's why I draw the distinction between legal knowledge that's in your brain and legal research that might be on paper. I agree with you there. I think those are two different things.
Evan?
What about the sort of squishiness of the generally known in the local community or trade field or profession?
I'm concerned about that too, but I'll shut up.
I mean,
I'm persuaded that leaving that out may make sense. I do think that's just, that may be overly broad and squishy. So I think Todd's convinced me to take out the generally known piece. So I think where I'm landing is something like 1C, but adding in legal knowledge or legal research is something that I think I could support.
Evan, so is everybody in agreement that the first option is out?
Raise your hand if you're in agreement that the first option's out. That's okay. That's unanimous. So first option's out. Down to B and C, or a sort of a hybrid of the two that blends the two together. More towards C, I think. Bill?
I agree that the baseline for me is C, public record exception. Having public record, things that are in the public record remain confidential to the lawyer doesn't make any sense, particularly when you've already disclosed it in the public record in a lot of different ways. The things you file with the court, exhibits that you file your summary judgment motions, you've already disclosed them, the third parties to the court, and they become public record, and that just doesn't make any sense to continue to include things that are in the public record as confidential. But and I think we all are there, but the more things you put in, the more things should occur to you that ought to be put in. So I opt for the simplest version usually, but I can be persuaded on adding things to 1C.
So let me ask if we pretty much got consensus that at a minimum we're going to include what's in option C, public record, and how we build that out is to be determined as we go forward today. Does everybody agree with that? Let's vote on it and see how Dion, Bill, Amy are okay. All right, that's unanimous also. So, all right, so C is going in, and the modifications now, I think, or the additions are open for discussion. And I think it's pretty much limited to what Todd and Mark and Jack were talking about, and that's legal knowledge, research, or information, and how much we qualify that. It's generally known in the local community. Yeah, go ahead, Amy.
Well, and I think Dion was before me. Go ahead.
Well, then the other thing that I'm still kind of hinging on is whether or not, if it is out in the public, can our clients tell us not to,
Good question.
and then again, hinged to that would be, do we have a duty to ask our client, or does the client just have that power that we sort of lay and wait and let them make the first move?
Yeah, I'm glad I let you go first. That was going to be my point also. Well done.
If I may share something, as we've been talking, I put this together. I don't know if this is capturing what we're talking about, but this would be option 1D. But confidential, this is the terminology of, again, confidential information consists of information gained during or relating to the representation of a client, whatever its source, but does not include a lawyer's legal knowledge or legal research or information contained in the public record. So that is the definition of confidential information. But then in 1.6, it would be amended to say a lawyer shall not reveal confidential information acquired during the professional relationship with the client unless the client gives informed consent, disclosure is impliedly authorized, or disclosure is permitted by paragraph B. And then adding this sentence, a client may request any information acquired by a lawyer during the representation be kept confidential. I think that's getting to the question that Dion, you just raised of, should the client have the ability to do just this? And that is an interesting question. So I don't know if this is helpful to kind of continue the discussion in the direction that it's going, but hopefully so.
Well, does that put the onus on the lawyer to give informed consent in all cases, in all clients, at all times, really?
I think you could make and I guess this would be the part of that calculation or the evaluation, right? You could say that under Rule 1.4, we as lawyers have a responsibility, a duty to inform our clients, to explain matters to the extent necessary to allow them to make informed decisions. And is this one of those informed decisions that it would then be a duty? I guess maybe this would come out in an ethics opinion, subsequent ethics opinion, that lawyers do have a duty to explain to their clients, if you want any of this stuff kept confidential, you can tell me. But to inform them of that option. I don't think it's appropriate to say, client, you have a responsibility to be familiar with the lawyer's rules of professional conduct. But to put that on a lawyer, I think there's an avenue for it through 1.4. Whether we think that's appropriate is an entirely different question. And I think that's what perhaps we should discuss.
Well, that's Bobby Kahn over in Union County, who remarkably reached out to his client to see if the client would consent to his discussion of that sort of landmark Supreme Court decision. And so it would seem that it would, under 1.4, that would be a requirement. To me, does anybody else have anything to say on that? Dion, help us here. This is your issue.
Well, I can just hear folks in my district, who would want to, for instance, use it, talk about their big thing that they've devoted their 2 years of their life to, they think would be helpful to other folks, but they can't get the client to agree that this could actually help them. And I can see him being angry about it. If the client maintains the ability to keep something that's in the public record out of that attorney's control to use it. But, I don't know that that's a bad thing. It just, it comes down to all the things we've been arguing before, the guy who's just sitting passively in the courtroom listening to this can go in and present a way, but the attorney can't, because this client has the ability to basically draw the line. And, I'm just saying, this is just, I don't know how I come down on it, because I can hear the arguments in one ear, and I can certainly see where a client may say, yes, attorney, but because of the relationship we have and you're on my team and I need to feel like you have my back all the time, I don't want you talking about it. Because people may perceive it and give more importance to it. And you may be bringing it up when people have forgotten it. All these things that a client needs to feel, again, that like they've got their person, that if they aren't going to talk about it, I should be able to tell my client not to talk about it, or my attorney not to talk about it. But anyway, those are, I haven't had a comment because I haven't come down on which side, but it's tough because I'm weighing both ends of it.
And can I add something just quickly there, which is I'm struggling with this a lot too. I will say I was actually in a situation where in my youth, I did a murder case that had some notoriety, and then it somehow ended up on a podcast called Crime Junkies or something like that. I don't know. But I got a call from the podcast people wanting to comment on this case that's now like 10 years old. And I didn't want to, but I called my client anyway, just to give them a heads up that this was going on. And it just brought this to light to me, just right. Like this could come up. And I also realized like me saying something on that podcast would mean something different than a journalist who sat in the courtroom during the murder trial.
That's true.
Right. And I'm using something that's an extreme example, but I do think that matters. Like, even if I was talking about what was on the public record, I know more than the journalist does because of that special attorney-client relationship. And so that's really something that, like, yeah, it's awful if you dedicated your life and you could help other North Carolina attorneys. That's the other side, right? Like, you learn from this case, you could help other clients indirectly by giving a great CLE. But is that counterbalanced by the fact that, like, the reason you know that is because a client hired you to have that, those 2 years and have that relationship. So that I'm just struggling with that also.
Well, I think it goes back to Bobby Joe's point that it is the client's case and the client's information that she made previously. Go ahead, Todd. I can't see the full board with Brian.
Mark also has his hand up.
Okay.
No,
Sorry.
Evan, I was going to make the point that you just made. I mean, you guys will probably get sick of me saying this, but I strongly believe that our charge is to protect the public, and that when there's a hard decision to be made, we tip the scales in favor of the client, even if our lawyers who we love and love us are going to be ticked off at us. I think if it's a question that's a close call, I think we have to come down on the side of protecting the public and maintaining the trust and confidence of our clients and lawyers. And so that's sort of my view on that. And Evan, I want to, you can go and get whoever has their hands up, because I can't see them either, but I want to.
I can't see. Brian's going to have to moderate that.
Are we talking about what? I don't know what your comment was. What was your question on 1D? Were you asking us for consensus on 1D? Well, I didn't get it yet. I'm sorry.
1D is this, that we stand pat, that 20 FEO 6 as written originally in the NRA Con be our report back to the ethics committee with no modifications or changes in the rules at all. But I think that by what I see as consensus, we pretty much agree that 1C is ought to be written into the rule change with what any other clauses that we think might be appropriate. And also any additional information on 1.6 that Brian put up on the board. But I think 1D might be off the table because I think we've got consensus that it needs to be moderated. Am I wrong on that, everybody? Mark, go ahead.
Yeah,
I agree with you, Evan, except Brian now has what he's called a new 1D, which, he had.
That was
up on
my
the
fault. I
screen.
should make it 1E.
Maybe it's E. Maybe it's E. And Brian, you captured exactly what I think I would like to see, which is 1C with adding in the legal knowledge and legal research. So that would be the version I would support in terms of a change. On this issue about client control of the information, I think we need to serve the public, but I come down not including that language because I think the broader public is served by the ability to perform education and talk about what is a matter of public record. And I don't see a need, if a client wants to enter into some contract to gain, some rights or restrict a lawyer further in terms of what they can say, even if it's in the public record, I would leave that to some kind of discussion or negotiation outside of the rules of professional responsibility. But I don't find it an ethics violation for you to talk about what is already a matter of public record. If you're not sharing it and it's already out there. So I would vote against including that additional language. And I do worry about the breadth of it, that the client can designate anything. I don't want you to say you represented me in that case before the Supreme Court. I don't want you to do that. That's about the case. And the fact that you were that lawyer, you shouldn't be allowed to say it because, and I think that goes too far, in my opinion. We have a public interest in lawyers being able to talk about what the record is in a case and what the record was, and the lawyers involved in that case are knowledgeable about what is in the public record. I think they should be able to do it, and I worry about a broad carte blanche. And to Evan's point, I worry that if they're allowed to object and then you have to inform them of their right to object, you get into this circle where they're like, well, why should I give consent? The answer is because it benefits the entire community of North Carolina to have this information shared in CLEs and articles and other information. Why are we putting the rights of that one often former client that you represented years ago above the interests of everybody else in the public to have accurate information about what happened in a case and provide learning opportunities for other lawyers? So to me, balancing public interest, I come down in favor of not including a blanket carte blanche that the client can just say, you can't talk about anything. I worry that's overbroad.
Yeah, and I echo that, because it seems to me, as written, it would be implied that the lawyer has a duty to reach out to the client whenever there's a public discussion of the case, and at all times, because as I think, who was that Amy said, talked about the murder case 10 years later. I mean, you reached out to your client, I think, but still that's a burden that I think is untenable. And I think it also opens the door for some of the more unstable clients to file with grievance that they were not notified. And so I agree with Mark, even though I'm chairman, I'm not supposed to weigh in on this stuff, but I think it just creates a whole nest of problems.
I'm not clear what we're voting on. Is it 1D that we're forming consensus on? Is it 1D that Brian put? I mean, I'm trying to understand so I can vote accordingly.
Oh, it's
1E now.
1E.
Yeah.
Okay. I thought that was it. And the only question I have, Mr. Chair, and I don't want to prolong this, is what's the committee's sense, if there is one, as to what's included in legal research? As I said, I mean, if the client asked me to do a memo in response to a specific legal inquiry, do I have permission based on the way we're getting ready to approve this, if we approve it, to be able to use that memo as I see fit?
Well, not the memo, but maybe the research.
Well, the research is going to be based on the law and the statutes, I guess. I'm trying to draw it. But I think that memo is usually going to. I guess what I'm talking about, the document that I sent to my client that they asked me to prepare, that I might have, privileged and confidential across the top. I mean, what are we saying about that type of memo? Not a brief that we file, because I think that's public record, but the way this is written, I don't know, is it legal research that's not committed to writing? What are we saying there? I want to try to be as specific and particular as possible, is all I'm suggesting.
Right.
to me, the legal research, Todd, would be the analysis of the case law and stuff. The memo may have confidential stuff unique to that client, and clearly that's still protected by attorney-client. You can't take that memo and share it with another client or publish it on your website. But the research, if I want to block and copy the research section of that memo, if I've researched an error legal issue for client A, I think I'm free to block and copy that legal research from client A and put it in client B. And as you know, we do that all the time. The whole purpose of brief banks is we share all the knowledge of the law firm so we can do more efficient work, for all our clients, because I've got access to 1,000 research memos.
I agree. That's what I want to understand. And I agree with you that internally we cut and paste all the time. There's no reason to redo that. I'm just trying to understand exactly what the committee is thinking when they use the phrase legal research. I'm sure.
That's what's in my mind. Again, maybe we need more definition, but that's what's in my mind. So if the memo, often it's a blend of client confidential stuff, the client presents this problem, clearly that's confidential, but then it's got, case law and analysis or like a draft memo that isn't filed, that's the legal research piece. It's the give me a memo on what treble damages look like in North Carolina answer that would be the legal research that, even though it's done for one client, it's still not confidential client information because it's the raw kind of it's non-specific to the facts presented by that client. It's a general state of the law research.
Is it sort of correct to assume that by legal research, you sort of are talking about the lawyer's legal analysis, mental impressions, things of that nature, as opposed to what might be confidential, factual information that client has provided to you?
I think it's legal analysis with regards to the state of the law, and not necessarily with regards to the application of that law to the client's specific facts. And I think we could flush that out in a comment, just to clarify that.
Okay.
And I guess I think of it as kind of the inverse, and that question that I've dealt with or have posed to me over the past couple of months of, if you write that memo, Todd, and you did not have the legal knowledge and you didn't conduct the legal research on whatever topic you're talking about before that one client came along. Now you have acquired new information during the course of your representation. The question has been posed, well, is that confidential? Because you acquired it during the course of the representation.
Yeah, right.
Technically, under our current rule, I feel like the very technical and dissatisfying answer is yes, it is confidential. And that presents a limitation, arguably, on the lawyer's ability to represent a subsequent client with the exact same issue and say, I researched this, I know exactly what the law is, and I want to just take that chunk, like Mark said, I wrote a memo and I've got 2 paragraphs on the law, and I want to go ahead and share it over here. Under the current version of the rules, there's an argument that you can't do that. I think it's totally impractical, and I do not like that interpretation, but that's where this could clarify that. And so I think maybe a comment could be drafted that would clarify legal knowledge and legal research really pertains to the lawyer's analysis of the law and is really separated from, devoid of any mention of prior client specific information or application of law to that client's facts.
Yeah. I agree with that, Mr. Chair.
Perfect. But let's I think, do we have consensus now on at least that part of option 1E as it's written? Brian, can you put the full board back up so I can see who's voting on this? And then we'll talk about the other part. So it's Bill, Dion, Amy, and Jack, and Ellen. So you're on the committee too, Todd. Okay. It's unanimous.
I think I am. I
Yes.
think I am.
Oh, you are?
Yeah,
Okay.
you are. Yes.
I thought you were
Unless
the
you kick me off,
emissary from the disciplinary committee. Make sure that we didn't tangle everything up over there at grievance.
Todd, that's why you lost connection before. Evan was booting you out of the
That's what I was saying. You must have booted me off of the committee, Evan. That was it. I thought I was.
All right. Well, let's go back to Dion and Amy's issue, which is the last part of 1E there, and Ellen's too. Whether or not the client has the absolute veto power and ability to cancel any discussion, any public disclosure or revealing of information or use of information at all times.
I've been persuaded by Mark.
Okay, Amy. I mean, I know this is you're having trouble swallowing here, so.
I am persuaded by Mark in some ways, but can I make one point and then I'll let it go, which is just because that attorney can't do it doesn't mean someone else can't do a CLE. This doesn't mean that it never sees the light of day, right? And I'm also concerned if you do it without client permission and you're like on the news, like me talking about my murder case, and my client sees it, that seems like a grievance to me, right? Like suddenly people are writing to, when Todd was on the grievance committee, like Amy went on the podcast and talked about everything without even calling me. So, but can you see, I can just work myself in a circle on this. So maybe Todd, I don't want to call you out too much. And Deanna, I don't know if you have thoughts too, but like kind of your experience on grievance, if you have an instinct on this, because what I don't want to do is put people in situations where their grievances that, what I mean? Like that's the last place we want to be.
Yeah, I'll tell you, based on what you just described, I suspect you might, if the client knows about it, you might get a grievance filed against you, quite frankly, based on the example you just described, quite frankly. So I too am concerned about the client not having any say over the use of his or her confidential information. So I'd certainly appreciate Mark's well thought analysis, but I'm sort of coming down on the side of I would like to see the client have some say in the use of his or her confidential information that a lawyer comes into contact with only because of the commencement of that relationship. And I think Amy makes a good point. We're not prohibiting the whole profession from learning about it. We're simply saying that the lawyer who represents the client is sort of at the good graces of the client, which I think is how the rule is currently written as well. So those are my thoughts on that, Mr. Chair.
Well, is that going to impact how lawyers really conduct business in 2021? And that is putting on their websites and their brag boards and their everything, the cases that they've handled, to give sort of a representation of what they've done and how they've done it. I mean, as a practical matter, lawyers are pinning stuff on their websites every day and in violation of 1.6 as it sits right now. Amy?
Yeah. I mean, I will say in my engagement letter, I get this informed consent in the initial engagement. Like, you are consenting for me to be able to do blah, 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 right? Like depending on who the client is. So it's a problem that can be solved right at the beginning of the relationship, right?
That's right.
It can be. I think, go ahead, Dion.
Well, but don't you think that the way that don't you think that that client would always be able to change horses as the case progressed and could easily, without your consent, withdraw that, and then you're stuck in the case?
Right.
Also,
it's tough because, go ahead.
I'm sorry, I think we talked about this in one meeting. I get confused between the different subcommittees. Anyway, it would be difficult to get implied consent to you can't really get implied consent to everything from a client in the
I think you mean
retainer.
informed consent. Yeah,
Yes, I'm sorry, informed consent in the retainer agreement. And I think we've talked about this before.
Yeah, it's like an advance waiver type-esque issue. Yeah.
Right,
Good
right.
point. And so, that worries me. The other thing that Mark said that was, I love a slippery slope argument, because, it makes me nervous that you could even be barred by your client for even saying that you were there, that you were involved in the case, that you signed pleadings. And I know that if, you could do that if you were defending yourself, against the client, but can they just even, obliterate your presence at all by just telling saying you just can't talk or say anything. If another attorney knows that you had the case, and the day after the hearing and they call you and ask you something about what happened in the case, and you just slip up and say, oh yeah, we won that, or judge didn't see it that way, is that gonna cause a trigger?
Well, let me, I'll go ahead, Ellen. I'm going to pose a question in a minute. Go ahead.
Just real quick, I think Dion hit it on the head with the line drawing. And I just want to say, about being persuaded by Mark. I mean, Amy raises a point that has been raised by a lot of scholars post the Virginia Supreme Court case, that basically, now a lawyer can, with impunity, right, use this information in the public record to harass their client, embarrass their client, do all of these things. This should be a violation of the duty of loyalty. I mean, that is what a lot of my teacher colleagues are saying. And I would expect that should this rule go before the bar, we would hear a lot of that. So I want to acknowledge what Amy's saying and recognize she's not on her own. But I think it is a line drawing issue, and I don't know how we do that. Sorry, Evan. Thank you.
That's okay. Jack, come on and weigh in on this.
Yeah, thank you. No, right. And I'm vacillating like everybody else. But I do want to say, I also agree with what Mark said. And I think that my initial comment about how language that could be used to kind of tamp down on how the public record thing was going to operate, I think I've changed my mind. I like this new 1E. And I think that trying to create a mechanism by which we prevent lawyers from improperly using information about their client in toto, like trying to create I think at some point, lawyers have to be trusted that they're going to use proper discretion, right? Like, so the initial hypothetical I was talking about was, okay, there's Amy, I think was talking about information about an affair that somehow was part of one of my mortgage cases, right? That came up somewhere in a public record through a motion, through a brief, through whatever. And I think I was going down a rabbit hole of thinking, yes, how can I prevent a lawyer from being able to talk about that client information? And thinking, well, if I'm giving a CLE about negotiable instruments, that would have nothing to do with it. And at some point, they're going to have to trust the fact that as their attorney, I wouldn't be traipsing their dirty laundry through my CLE presentation over at the Cary Bar Center. But although I would know that everyone in the Cary Bar Center would want to hear that information, I would have the discretion as an attorney to keep it out. Now, that being said, I want to say that what Ms. Murphy was saying there a second ago, Ellen was saying, I hear what you're saying, but I think that what Dion was saying, at the end of the day, I think I've changed my mind during this conversation because I think that I've come to the decision.
At least twice, Jack. Yeah.
No, look, I mean, this is what's great. I read this information, I thought this through, and then you much wiser people were able to convince me of the error of my ways. And so anyway, I'll shut up, but there's no foolproof way we're going to prevent attorneys from talking about all of the craziness they learn representing their clients, because we learn a lot of craziness.
Well, let me ask Brian.
I'm not going to talk about it when I'm talking about mortgage stuff. I'm sorry, Evan, I'll shut up.
Yeah, let me ask Brian and Suzanne this. Are there other protections, sort of prophylactic protections in the rules that would meet this issue?
Yeah, well, yes and no. I think you could, and I'm looking up the exact language. I'm thinking of 4.4 here.
Yeah, that's the only one.
Because 4.4, it says that lawyers are not to do anything that's embarrassing. Whereas in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person.
Right.
It does not pertain to a client. And I think it's kind of a presumption that, well, no lawyer would ever do something to their client that would be embarrassing or burdening. And maybe that's an incorrect presumption on the rule's part. But I think that's a potential avenue. Although the rule, like I said, doesn't necessarily apply. Whether something is prejudicial administration of justice, I mean, that's an incredibly broad rule. And I don't think the Office of Counsel generally does not like to use that rule as the catch-all. I think they reserve that for things that actually do inhibit the administration of justice, the actual carrying out procedure and things of that nature. So I do think that's one where 4.4, it seems like it's the natural fit, but the language would arguably exempt all that. And so you might not have any sort of protection. And I'll just say, this is really, Jack, this illustrates kind of the struggle that I always have in this, coming from the Office of Counsel prosecution stuff. And now where you deal with the folks that don't, I guess you see the worst sort of fact scenarios and the lawyers that do the wrong thing versus the ethics side, where lawyers are doing the right thing. They're asking the question in advance because they're trying to do the right thing and trying to draw that balance. Do you create a rule that really addresses one group or another? And I think that's where, Todd, to your point, you tip the scales in favor of the protection of the public, because there are folks that could, for example, under this rule, if you don't have that type of protection, do like the notion of posting your stuff on the website, on your own website. Right now, a lot of folks, they can post hypotheticals, or they can post very generic terms. We obtained a verdict, as long as it's true, a verdict in such and such case and things of that nature, with different limitations, of course, that are in the ethics opinions. But under this, arguably, I think a lawyer would be able to say, represented Todd Brown in his claim of fraud or whatever it is, against Google and things of that nature. You can get a little bit more specific, as it is specific in the public record. Is that something that we are comfortable essentially opening that door? Well,
let me ask Suzanne and Brian this: can we meet this issue with a comment that ties this stuff together rather than put it in the rule, that kind of puts lawyers on notice that there are these obligations, as opposed to making it a rule violation, which is going to open the floodgates to Todd's committee?
Yeah, I think, a comment can, if you want the language to be a lawyer should speak with the client, then a comment is sufficient. But if it is a duty imposed upon the lawyer, it needs to be in the rule, because the Office of Counsel and just our general disciplinary process enforces the rule and not the comment. Right. So I think that's a line to draw there.
Agreed.
Bobby Joe, I believe, has joined us now as well.
Hi, Bobby Joe. Welcome.
Hi, thanks for having me.
Yeah, you've missed a very engaging discussion here for the last almost 100 minutes. Well, I don't think we have consensus on this issue.
Bobby Joe, what we're talking about right now, we've come up sort of with a potential rule, and maybe Brian can share his screen again, but the issue that we're struggling with or discussing right now is whether, regardless of what the rule says, whether the client should have the ability to prevent a lawyer from disclosing information, even if it's not protected by the rule. Can the client still tell the lawyer, no, you can't talk about any information in my case? And that's kind of where we're.
Well, I did look over these options,
This
or at least
is a
some
new
of
one.
them. This is a new one. Okay. Well, I do have to say, I'm not sure I can comment in the sense that I don't think the rule should be changed still. Is all I can say is I want my lawyer to be the one person in the world who can't talk about the information, even if it's public information. I want to rely on the fact that I can rely on my lawyer to not talk about it, and so I would, I guess, want, if this is what the new rule is going to be, And if it's going to include information in the public record, then I would want the client to be able to veto it, and which I guess would mean you'd have to get informed consent. But again, coming in late to the conversation, I don't know if that's how this rule works, because if it's not confidential information, then why would you need informed consent?
And
You wouldn't.
yeah, but I think Bobby Joe, we've pretty much reached consensus on option 1E(b) on what the definition of confidential information is. And I think we got a unanimous vote that this ought to be presented to the full ethics committee for discussion. And I'm going to say this is going to keep the ethics committee busy for hours, I think, once we get this in front of them. So, but the next issue that I don't think we have any close to consensus on is whether or not a client may request any information acquired by a lawyer during the representation be kept confidential.
Well, certainly they could by contract, right?
Yes, and Amy writes it into her contracts, and so yeah, so she's already ahead of the curve on that. So who else? I don't have a full screen, so I can't see. Anybody else want to weigh in on this? Brian?
Evan, I'll be real quick. I'm where
Okay.
Bobby Joe stated my position clearly. I'm where she is.
Okay, Amy.
Well, can I ask a procedural question? Do we have to have a consensus to send it to the full committee? Because
No,
Like-
we can vote. It just seemed like
Right. I mean,
everybody
so
was.
I don't want, because I like understand and feel all of these arguments. And part of me wants to talk to even more attorneys in different practice areas and parts of the state, right? Like, I know I have this like professor side of me, and then there's practice side, right? And I think we need to really meet the practice side pretty hard too. So I just want to say, if I don't vote, it's not because I think it needs to go to the full committee and get more info.
So let's see, Jack, you want to change your mind again?
Hey, come on now.
Hey, come on.
That's
We've been on
evolution.
enough committees to get-
I'm evolving my thinking based on what Mark said.
Hey, listen, we thrive on rejection and humiliation. We're lawyers, right? So, well, it sounds like, I don't know, Brian, help me on this. Do we want to take a vote on this, or do we want to table this for further discussion and
Well,
contemplate?
I wonder if, to what Amy just said, this is one that, we'll put it this way. I think presenting this, we don't have to rush to present this to the ethics committee in July. If we all feel like we're kind of set in what position we're in on that particular point, we could take a vote and we could submit it to the ethics committee with a report that this second component, the client veto, essentially had a split vote, whichever way it comes out. But the other option, I think, is that, yes, we could continue to discuss. I could send this out to everybody. And really, we could do almost like an informal pre-publication to not anything official through the state bar, but just if we're all trying to figure out where do we really stand on this, we can solicit additional information from other folks. We could ask whether it's bar association divisions, the advocates for justice. I know Abby's here, to send this around and just to get that sense of what does everybody think? I mean, ultimately, we don't want this. I don't think the rules necessarily need to be molded based upon like a popularity context. I think we need to do what is the appropriate thing. But if we are still trying to figure out where we as the representatives on the State Bar Council, or you all, not necessarily me, but if you all as the representatives on the State Bar Council, the ethics subcommittee are standing, then we can take the time to do that. So if you all feel like you need a little more time to mull it over now that we're kind of drifting towards consensus, then feel free to take that time.
Well, we also have some work to do on possibly drafting one comment or two.
Yes.
So that's before we do anything, I'd like to see those comments and bat those
No,
around.
that's a great point. That's a great point. Suzanne and I can get to work on drafting those. So maybe it would be the best course then. I mean, I think this is a very productive meeting and we see a direction and we can create some proposed comments and see how this would flush out in, the impact, the ripple effect really on 1.9, 1.8 and so forth. And really even looking at some of our ethics opinions. How is that going to impact the current standard? I guess I'm still in the anti-discrimination subcommittee hypothetical mindset. Maybe we start thinking of how is this going to play out, and draft some scenarios to see, do we like how this is actually going to play out, to facilitate that discussion. If we're satisfied with it, great. If something raises a concern, we address it. So it might be that this it's not right to send to the ethics committee just yet.
I agree. Do we have consensus on that? Everybody raise your hand. We're not ready to send this to ethics yet. Dion, you want on that? Okay, Todd, great, Jack. Okay, I want to ask Deanna Brocker if she's got anything she wants to say. She's been listening, I think.
Is that Deanna?
Hi, yeah, I'm here. Sorry about that. Can you hear me okay?
Yeah.
Yes. Okay. Yeah, I have been listening. Thank you for letting me be a fly on the wall. I have been sort of living with the rule as it stands for so many years. This may be something to be said for how many years I've been practicing, but I am reluctant to change it. I sort of am coming down with Bobby Joe Boyd on this one. It gives the rule as it stands gives me certainty in how I can advise clients, gives the lawyers certainty. And so I'm not saying I'm going to be against it for sure, but right now I'm still convinced that where we are is a good place to be, but I'm looking forward to seeing what the drafts look like in the comments. Thank you.
Thank you, Deanna.
Thank you, Deanna. And somebody from Lincoln Durr is on. I don't know if they want to weigh in on anything. I don't know who it is.
Hey, this is Sarah Lincoln. And yeah, I've been listening. Thank you for letting us listen in. I appreciate it. And I think I'm with Deanna on this one. I'd like to see what the redrafted proposals look like and what the comments look like before I really come down. I was pretty opposed to what the proposed opinion looked like. It was, I thought, a difficult burden for lawyers to navigate. I do have one concern that I think everybody should think about as y'all are redrafting things, and that is, this is likely something that is simply going to become law firms including in their engagement letters a waiver of the client's right to object to the use of their information. We have a lot of standard language that we've been putting in our engagement letters for years to address issues that are raised by the state bar, and it's kind of form over substance that at that point, if that's what law firms are going to be doing. But it's just something to keep in mind as you're going through and making your additional comments and doing your drafting.
Thank you, and thank you very much. All right, is there anything else? Are we ready to close up shop for the day and agree to meet at a date yet to be determined? And Amy and Bill, you're going to present to the full ethics committee sort of a progress report, right, you guys? And try to avoid any stray bullets from coming from the ethics committee. So, all right. Anybody have anything? Jack, what do you have?
Just on a unrelated matter, this is a question for Suzanne and Brian. Do we have any word yet of whether or not we're live and in the mountains now?
I think we are.
We are. Ethics
Awesome.
Ethics is going to be Thursday morning in the mountains in person. So
cool. Awesome.
Yeah, we'll be in touch. I know all those different details are still being ironed out.
Okay.
Trying to minimize the gatherings of individuals in one place and so forth. But yeah, we'll be in touch shortly.
Thanks, Brian.
And I think, Jack, that if you're willing to share it, Sharon up at the bar wants to know if you've been vaccinated or not.
I have been vaccinated.
Good. Yeah.
I'm coming. Maskless.
Well, send Sharon an email and tell her that you've been vaccinated. So that way she knows kind of how to structure things a little bit, I think, because she's the choreographer here. All right, is there a motion we adjourn?
So moved.
Second. All in favor, raise their hands, and we are adjourned, sine die. Thank you all very much. Great meeting. See you.
Thanks.